first. This is for item 54, so go ahead.
Thank you, Mr. Chairman, and thank you, council. Appreciate your
Legal
time
stuff.
today. This is an important issue. The state legislature had several big bills this year that have changed the landscape a little bit in the quasi-judicial arena, and this is one of those issues. Specifically with regard to HB 7103, there's one in particular provision that will impact your quasi-judicial matters today, which is why I have asked to speak to you. And my apologies, Kristen Moore, Legal Department, and good morning. So this is a change to 166.033, and it requires that an approval with conditions or a denial of a quasi-judicial matter, specifically any development permits, will require you to have written findings in your decision. So the clerk is going to have to reduce findings that you have made and put those into your decision so that it can go out in order to be in compliance with this requirement. As you know, previously you've always had to cite a code section or something relevant with regard to denials, but with regard to approvals, you've simply read them and moved forward. But you now have to have written findings, and it is plural, implies at least two findings in order to support your decision. Those findings must be findings relevant to your decision. So, how do we go about doing this? The easiest way for the clerk to get this down and for council to put this together is to follow to a T Robert's Rules of Order. And Robert's Rules of Order calls for a motion and a second, then discussion, and then a vote, always in that order. This is important because a lot of times, and council is generally pretty good about this, but it does happen, sometimes there's a lot of discussion, and then it's good discussion, but at the end of that discussion, it's a reference back to and everything we just talked about as the reason for the motion. And unfortunately, with the new state law, that's not going to give the clerk enough information to be able to get those written findings on the record. So it's really important that when you close the public hearing, that the first thing that happens is a motion with all the written findings that you can put in there to be stated. So what goes in this motion? Because you're going to need to have something in this motion, and what is that finding? Ideally, you'll cite to the code sections. And in most of your quasi-judicial matters, specifically in your review hearings, for the most part, in your rezoning applications and in your alcoholic beverage applications, you're going to have staff reports. And those staff reports always contain the individual code sections that are relevant to your consideration. So that is the best place to go to say, all right, what am I talking about in this particular application, and what do I need to be looking for? And then you'll add into that facts that you either find in the staff report, or you may add in facts that you hear at the public hearing in order to build them into those code criteria. You can also rely on expert opinions. The staff that comes up and speaks to you are experts. We have planning experts that will speak to you. When there's transportation issues, we will often have someone from transportation that is a transportation planning expert. And so you can rely on their opinions. In addition, if applicants or even if opposition groups have experts on particular issues, you can consider those expert opinions. But everything that's not coming from an expert opinion needs to be a fact-based issue, not an opinion. Would encourage you to consider making notes during some of your hearings. A lot of times you hear a lot of testimony, and by the time you get to the end, you've forgotten what that one very important witness had talked about. So do please think about making notes so you can help you to do these findings. And please feel free. The motion that you make is going to be the motion of City Council. It's going to be the findings of City Council. And it's going to be very important in those, if it gets reviewed in a court, what was in those findings. So please feel free to add on. Just because one of your other council members made the motion, please feel free to add something if you can think of another fact that they missed or some other finding that you think is important to the issue. And then after that motion is made, then discussion is absolutely proper, and then ultimately your vote. So just to walk you through a little bit about these motions and what you're going to want to see in them. This is a new requirement from the legislature, but it does fit nicely into what we've always said in the law about quasi-judicial hearings, and that is that they're like trials. They're little mini trials, and you're all sitting as judges in those. And you're applying the policies and the law that we have on the books on that day to these particular facts. This is an important point. You can't create new policy during that particular hearing. You may be inspired to create new policy as you see something come towards you, but you can only apply the law as it sits that day to a particular item. If you feel a policy should change, that's appropriate for discussion down the road, but it's not an appropriate thing to apply to this particular application. Well, why? When these items go to court, in most of the ones we'll see is called a writ of certiorari, and the judge is looking for whether procedural due process was afforded, whether the essential requirements of law were observed, and whether there was competent substantial evidence that supported your decision. And the issue of applying the policy as it sits today actually deals with two of these prongs, and the first one is procedural due process. So procedural due process requires notice and an opportunity to be heard, but not just any notice and not just any opportunity to be heard. It must be meaningful. And in order to be meaningful, they have to know the law that they are trying to meet when they come and speak before you. If you change the law during the hearing, they don't have an opportunity to bring forward all the facts that may have met that law. So that's why it's really important. It's only what you have on the books policy-wise when you hear that hearing that you can consider those. And that is what should go into your motion. When you do these motions and you're doing the findings, you're going to want to look to the existing law on the books and not something that you would like to see in the future. Also relevant under due process, again, uphold the law, and you have to be impartial. Impartiality is a big part of it. And you have to listen to the testimony that's offered. You can also elicit testimony, but you cannot offer it. So if you, and all of you know our city very well, it's one of the things that makes you wonderful council members, but you cannot offer the testimony. If you know that there is something in particular in that neighborhood, you cannot state that on the record. You can ask the witnesses about it and get them to testify to it, but you cannot offer testimony. And if you do hear another council member offer testimony, you have to be cautious in making a motion that you don't rely on that testimony from that council member, because that's not evidence that you can rely on for that decision. Ex parte communications is also something of concern in these quasi-judicial processes, as Mr. Torito mentioned earlier. You have to be very careful if you've heard from someone outside of this process that does not enter into your consideration and definitely would not make it into your motion. So those ex parte communications, they are the courts. I have a court case here. The court said that they're an anathema to quasi-judicial proceedings. So you definitely don't want any of that to accidentally bleed into your consideration. Essential requirements of law. What you should hear when you hear this is the correct law. And what is the correct law? It's just what City Council's standard is for that particular item. So, when you are considering rezonings, you're going to want to base your decision on the comprehensive plan as it sits at that day, the site plan zoning district criteria if it's a PD, and the waiver criteria, again, if it's a PD. So you're going to be looking at those specific code sections, which again will be in the staff report when you consider these. Special uses, very similar. You're going to be looking at the special use criteria, not the zoning criteria. And that's what's important here, is you're using that correct law each time that you're considering these. And in the event that you don't have a staff report that has that standard in front of you, it will be provided to you in the hearing. So just look at what's in front of you at those hearings to make sure that you have the right criteria. And relevant to your decision and your motion, you're going to want to make sure that motion cites that correct criteria. When you are doing the motions, when you're thinking of whether you're going to make a motion for approval or denial, You're looking for substantial evidence. Substantial evidence the courts have defined as evidence that's sufficient for a reasonable person to reach that conclusion. So you're looking, is there enough evidence in this record that I can consider that should tell me that this is the action I should take? And this is where it's really important. That evidence can't just be substantial, it also has to be competent. And this is, when you're making your motions, you're going to want to ask yourself, what facts do I have in the record? What things do I have in the record? What evidence do I have in the record that is competent, that I can rely on? And this is primarily going to be facts. And just as an example, if someone says, well, this intersection isn't safe, but they're a layperson, they're not a traffic engineer, they're not a transportation planner, that is just a layman's opinion and it is not competent evidence. You cannot consider it. But if they come up here and tell you there were 3 traffic accidents last week at this intersection, that is a fact. That is a true statement of fact, and that is something that you can consider. So you're going to be sitting there and sort of parsing and thinking about, is this an opinion, is this fact? If you need help, Mr. Shelby and I are always here to help weigh in on these things and what courts have found as opinion and what courts have found as to be fact-based. The opinions that you can rely on, as I mentioned earlier, are expert opinions, but they have to be an expert in that field. So if you have a transportation planner up here, but they tell you that this is going to lower property values, not competent evidence. They are not an expert in property appraisal. Only someone who's an expert in property appraisal can offer an opinion of whether something will raise or lower property value. So when you're making your motions, you'll be looking for that competent evidence that you can rely on. Okay. Rezonings.
Can I see? You want to
And,
wait till the
Councilman Carlson has it. Do you want to do it now or at the end?
If
or?
you don't mind, just
Yeah, it's probably, since it's a learning thing.
I met with Than and several of the other neighborhood associations recently, and they're all gearing up and educating each other. One of the things I talked to them about is having Rebecca or someone educate the neighborhood association activists, and I think most of them are very up to speed. But if we can do something like that, that would be very helpful to all of us. And then number 2. Is it possible to elaborate a little bit more at the beginning of these hearings to everyone in the audience so that they understand what we can and can't use? We can ask you questions with that, but assuming that there will be different participants in every audience, it would be good to be able to talk through that. And if we have a handout, that would be even better. But just so everybody knows we're on the same page, because as you said, if somebody doesn't want something but there's no competent substantial evidence, we can't use it.
Correct. Yes, that's a great idea.
And that's a very good idea. And Councilman Dingfelder.
The requirement for competent substantial evidence has been stated in case law going back to the Snyder case 20 plus years ago. Unfortunately, I'm that old. But it's sort of a comment and a little bit of a question. It's my understanding, correct me if I'm wrong, that folks who get up to the podium, even though they might be neighbors, can still provide us with competent substantial evidence. They don't necessarily have to hire the engineer to speak to us about the traffic in front of their house. They could provide pictures, that sort of thing, anecdotal evidence, that has some basis to it. And I agree, maybe something really technical like stormwater or something like that might require a little more formal training to identify where the rainwater is coming from, et cetera, et cetera. But again, I guess I want you to counsel us on that issue of what type of input could be competent substantial evidence, and yet it's still coming from that resident or homeowner. And finally, I don't want to discourage residents and homeowners and the typical citizens from coming down here and participating, especially if they do have some special credentials. They might be the neighbor next door who's against it, but they also might be a traffic expert, or what have you. So carry on along those lines.
Certainly. Yes, anything that's fact-based is competent evidence. So if someone comes in and they say, I can't even get out of my driveway in the morning, or when I pull up to this intersection, I can't see oncoming traffic, those are all fact-based evidence that you can consider. What becomes problematic is the superficial opinion of, there's a lot of traffic in this area, or there's too much traffic in this area, or I'm sure this is going to cause flooding. Those superficial opinions are what you want to be cautious of and not rely upon. But if they have fact-based evidence, for example, it's not speculative, there's already a use there, and it's very loud, and it creates a lot of traffic, and they want to expand that use. If those neighbors come in and testify about some of those adverse effects coming out from that business at that time, that is fact-based evidence because they're experiencing it. But if they're assuming that something's going to happen as a result of a business, that is an opinion and not fact-based evidence. So it's a fine line in many respects, and that's why I said please feel free to always reach out to either myself or Mr. Shelby or Ms. Kurt when she's here.
And if I just may follow up, that is a very fair question. Lay opinion is not competent substantial evidence, but the facts upon which they come to that opinion is competent substantial evidence because it's something that they have personal knowledge about. And that is competent testimony. The people who come before you don't know all that we are discussing today. So unfortunately, for instance, people invest their time in circulating opinion saying, I'm against this. And unfortunately, for them, you're in a position of not being able to accept that opinion as a basis for your decision, because that will be overturned. It is not competent evidence. My point is this. They may not know what you need to know in order to make a good decision. But with this help, you do know what you need to know. Therefore, you have the ability to ask questions. So rather than testify, if there's a fact or something that you want to elicit from the person who probably has that information, I suggest you do it, as they say in Jeopardy, in the form of a question. Take the opportunity to have the witnesses give you the evidence that they indicate that they need, but is not in a form that a judge will accept. You have that ability.
Well said. I completely agree. Okay, so in the packet that was passed out to you, there is a document that looks like this. It says rezoning motions at the top. This is intended to be a motion helper to help you think about these things and help phrase some of your motions. This has for approval as well as denial on these, and it makes some suggestions. You're going to refer to the staff report in these types of situations. I've also passed out to each of you an example staff report, and just wanted to bring a couple points to your attention on these. This is for a PD, a plan development zoning. And right here, you can see the waivers. This is always on the front of your PD. You will not see waivers in Euclidean zoning requests, but only in plan development zoning requests. But here are waivers. Anytime you have a waiver, this is a section of the code that they are not wanting to comply with. These are always interesting points that you're going to want to note as you hear these applications, and what type of testimony there is about how these waivers, consistent with the waiver criteria, are being otherwise dealt with, or the concerns of the code and of the comprehensive plan are otherwise being addressed. Here are the waiver criteria. Again, you will see these within the staff reports, and they will be there as well as some analysis of the waiver in these particular circumstances. Your staff report will have a summary of the request, and then what the staff findings are. So as you're looking for making those motions, again, you may also draw from testimony that you have received at the hearing, but this is a good starting place for you as you start to draft, as you start to put together your motion in your mind or with your notes, to look at what the staff is finding and to see, and you don't have to agree with staff, by the way. All you have to do is look at the facts that they're presenting to you. and give consideration to whether you agree or disagree. And if you disagree, you might want to think about what those bases are and what testimony you heard, what factual testimony you heard that supports that basis. So in the event you wanted to move approval, I lost my motion helper in that short time frame. That was quick. So let's say you wanted to move approval of plan development through zoning, you would move an ordinance, just like you typically would. Oftentimes with plan developments, as well as with alcoholic beverage applications, there are revisions to the site plan that are required between first and second reading. If you've heard that from staff, then you'll want to also direct the revisions to be made. And then you'll simply indicate that they've met their burden of proof, which is stated there, and then you'll refer to these findings in the staff report. That they have removed the trees as required by the code. They have the correct tree table. That they've otherwise met the criteria. That they've otherwise dealt with any waivers that they're asking for. So you'll go through each of those things and what testimony you've either seen in the staff report or heard that supports that. And you can also add conditions if needed. It's the same thing that you will see. And I have also provided this in the packet that you were given. The alcoholic beverage motions, very similar. You'll want to direct revisions to the site plan if you're moving approval on first reading. And then you will go through what their standard is. It's section 27.129 of the code. And then you'll want to state that it's compatible. If there's waivers to distance requirements, that there's been mitigation of that waiver, you can add conditions if needed. Similarly, if you go to deny, there is motion language grant that is here. And you would say that it's not compatible with the area, that they've not otherwise mitigated the waivers that they are requesting. And here are your general standards right here on the same page for you to refer to. And they are also in your staff reports. Here's a sample staff report on that as well. You can see here a finding of inconsistent. And then the waivers are all stated and shown. So you can refer to those very easily and quickly when you're putting your motions together and considering whether or not they have done them. There's the site plan, and here are the code criteria, all listed for you and for ease of reference. I have provided to you in the packet some items on conditions of approval. I can go through that with council very quickly, or I've tried to provide it in a format that should be very easy to reference and read. When you do the conditions of approval, you are similarly going to want to include findings that support the imposition of that condition and addressing that adverse condition, the adverse impact that the condition is intended to ameliorate. Any questions?
Any questions from council members? No? No? Councilman Carlson.
So one question is, how best can we seek legal counsel during, I asked you this before, how can we seek legal counsel in the public forum? We can call you up and ask you a question, but that's the only way, right?
Generally, yes. If you have a question, is this, if you need help crafting a condition, if you are uncertain whether or not something is competent evidence, then that is definitely what we are here for. Please feel free to call us up and we will be happy to address it.
Thank you.
If I could also follow up, and Ms. Moore and I have discussed this, especially with this process changing, the way the legislature is directing counsel, it's becoming less quasi and more judicial. And there are certain things that in order for us to protect the record, we will ask to be recognized to specifically give you guidance for the purposes of the record, to tell you that what somebody inadvertently is presenting you is evidence. It may be substantial, but it's not competent, and therefore cannot necessarily be considered as a basis for your decision, whatever that is. So that is some guidance that we are going to be proactively participating in to be able to protect the record and protect counsel from whatever decision that counsel makes. It is ultimately the goal to have it be sustained by a court. The beauty of findings of fact by this counsel is that in a certiorari review, judges cannot reweigh your evidence and rethink your findings of fact. So that's to your advantage, that when you hear testimony that is fact-based, that you put that into your motion, because that is a basis that you are basing your decision on, that a judge will see and cannot reweigh that.
All right, Councilman Dingfelder.
Mr. Shelby, I like it when we think alike, because I just scribbled on here, we are the finders of fact.
Yes, sir.
Okay, and I think I can't stress that enough to counsel. That hasn't changed, but it's important that we remember it, because it's an extremely important part of the process. And I also might even suggest that in this language that you're giving us, as part of the motion, say, and I might already say this, I don't know, but that as the finder of fact, we find these facts, and then that way it's right there for a future judge in review, and as Ms. Shelby says, that judge has to pay attention to it. It's right there. We are the finders of fact. Judges say it all the time over in the courthouse. And in this case, we are the finders of fact, and here's the facts we've found to support our motion to support or deny, either way. Thank you.
And if I could just follow up with one more point, Councilmember Dingfelder, that's an excellent point. The second shoe to that, the second step, is to take your code and apply the provisions of the facts that you have found them to that provision of the code to say, these facts support that provision of the code, therefore it supports my decision, whatever it is. Or in the case of the findings of fact, you're saying, these facts are in contradiction to the requirements of the code, therefore it does not meet the code requirements, therefore it supports a denial.
Because the facts that we're using need to relate to the law, the code, the law that's there.
Correct.
Thank you.
All right.
Excellent. Thank you very much for your time, counsel. If any of you need refreshers, follow-up, anything like that, I will always make myself available.
Thank you very much. We appreciate it. Moving along now.